Well, Justice Jackson was viewed, and I can think continues to be viewed, as one of the most talented members to sit on the court in this last century, in the 20th century. And that's all the more remarkable because his service was so short-lived due to his premature death. But he was known not simply for the elegance of his writing, which is legendary, spectacular writer, but also because he was so powerfully independent and really stood for the ideal of judicial independence. One of my favorite aspects of Justice Jackson's work is the fact that he, as a justice, took a different position than he had taken as the Attorney General of the United States and advising President Roosevelt. He issued a legal opinion as the Attorney General to the effect that the Lend-Lease arrangement with Great Britain was lawful under the constitutional laws of the United States. So then years later, he finds himself on the court, and that very opinion was being cited as a principal authority for President Truman's taking over the steel mills and directing the Secretary of Commerce, Mr. Sawyer, to take them over. And his response at the oral argument was just marvelous, that it was in his elegant manner, but he made the point. I was an advocate then, I'm a judge now. And he did not take that position as a judge that he had taken as a lawyer, and as indeed not simply a lawyer, but as the Attorney General.
Today, then?
Yes, I think it was Justice Jackson's concurring opinion in Youngstown that gave the most analytically impressive, call it taxonomy, of presidential power, and it continues to be viewed as the great source of authority as to where in our constitutional system does the president's power come from, what are the different dimensions of that power in the context of not simply foreign policy, but the use of military force and the like. And I don't want to say that it's the last word in terms of the analysis, but it's one of those principal sources of law that people go to in terms of what is the nature and structure of our government, especially with respect to the presidency. There's a Lincoln-like quality to his ability to articulate. But Barnett was the West Virginia case that, again, gave voice to one of the most important parts of our constitutional tradition, which is freedom of conscience. Justice Jackson was able boldly to guide the court intellectually to overrule a fairly recent opinion coming out of Pennsylvania involving the same set of facts, but with a different result. A very impressive opinion authored by Justice Frankfurter to the effect that the state could require children to engage in patriotic exercises on pains of expulsion from the school if they did not, and even criminal prosecution of the parents if then they didn't come to school because they'd been expelled because they wouldn't participate in the flag salute ceremony or the Pledge of Allegiance. And Justice Jackson in Barnett wrote, I think, some of the most beautiful and powerful language in the judicial literature about what this country is all about, which is tolerance of ideas, tolerance of the individual conscience, that the forces of the state have to respect the ability of the individual dissenter, even if the view is seen as very idiosyncratic, cranky, or the views of a crank, but that those views have to be respected as part of the human dignity. And he called it the freedom of the mind, which is a great way of expressing a lot of First Amendment values and concerns. But one can see a judicial philosophy at work. He certainly believed in the idea of the representative democratic process, and that judges should be cautious in stepping in and, shall I say, throwing their weight around, preventing Congress and the President from determining what public policies they thought were best. He, of course, had served in the Justice Department at a time when the Supreme Court was undergoing and then underwent a very significant change in attitude and philosophy, whereas in the early 30s, during the early days of the Roosevelt administration, virtually anything that the Roosevelt administration did that made it up to the Supreme Court got tossed out by the angry old men. And then President Roosevelt came up with the ill-fated court packing plan. That failed. But in the meantime, there was a change in membership in the court, but also I think just a growing sense that the court seemed to be going too far, declaring this act unconstitutional, that statute unconstitutional. And Justice Jackson was, of course, an advocate at the time, Solicitor General, Attorney General. So he saw up close and personal during those years the excesses of judicial power. So he became a justice then in 41. The court had changed its philosophy, but the change was very, very recent. So I think he felt that very keenly, that the court should play an important role, but it should be quite respectful of the democratic process. At the same time, in case after case, he showed how important he saw individual rights, individual liberties. One of the great legacies of Robert Jackson was his dissenting opinion in the Korematsu case, the Japanese internment case, where again he got it absolutely right, and going against the grain of the time, the current of the age, which is we're at war, so we're going to have to take these extraordinary steps in the interest of national security. His view was Fred Korematsu is a United States citizen. You can't treat him this way. You can't just summarily take him away and forcibly intern him at some camp in California away from his home and livelihood and so forth. That's not our nation. So he had great practical wisdom. You know, I note that he was very proud of being a country lawyer, and he wasn't burdened with too much education. His education was earned the old-fashioned way, and I think that may have aided the clarity of his thinking, as well as perhaps the beauty of his expression. He didn't take creative writing courses, he just read great writing.
What's the legacy of Robert Jackson? Let's just
One of unselfish service, including his willingness to be called away from service on the court, controversially so, to serve with renown as chief prosecutor in Nuremberg, and to develop in very short order and to present persuasively a case of, shall I say, universal significance. And it simply doesn't do justice to his performance to say it was of historic interest. It was of mega-historic interest. The idea that individuals should be called to account, the senior leaders of the regime should be called to account for their war crimes, very important, and led quite then overtly to important declarations like the Universal Declaration of Human Rights. That episode that he was such an instrumental part of just illuminated the path in terms of human rights now for perhaps centuries to come. It's as if we've all agreed, now it's a question of, we have a good design, now we need to implement, and he was at the foundation of that. And at the same time, he, during his relatively short life period on the court, became one of the most respected justices ever to sit on the court. I think universally agreed to be one of the great justices to serve, but certainly one of the great justices of the last century.